Hello. This is a brief video on confidentiality in the law firm. This is not formal legal advice. However, this is a general guideline on being professional in a law firm and maintaining confidential client information. It is to be used for teaching purposes. The following videos are two short videos on confidentiality taken from YouTube. This video is not monetized for profit, and all rights with respect to the two videos belong to the respective creators who are listed below.
Hi, my name is Ali Keegan, and I am a criminal defense attorney at the Law Office of David Shapiro in San Diego, where we help good people regain control of their future when charged with a crime. I am here today with one of our incredible legal assistants, Brooke Walker, to talk about a very common myth, and that is that confidentiality or attorney-client privilege only applies to the actual attorneys within a firm. And I've heard Brooke and our other legal assistants deal with this before, where sometimes we have clients or potential clients call in and they say, I can't tell you about my case. I want to talk to the attorney so that it's confidential or privileged. And we're here today to dispel the myth. So Brooke, let me go ahead and ask you, can you talk about our clients or our cases or anything like that at happy hour, at dinner, with your friends, or with anyone?
No, absolutely not.
And why is that?
Because confidentiality doesn't apply to just the attorneys in our firm. It applies to, anyone who's employed by our firm specifically, and in most law firms. So as a legal assistant, I do have that same level of confidentiality as the attorney, where anything that a potential client or a client does say to me will not leave the firm for any reason.
And that's actually something clients will hear in the first phone call I have with them or during our first meeting. I start by saying, don't worry, anything you tell me here today is going to be kept strictly confidential or privileged. It's not going anywhere beyond me or any member of our team, because we are all bound by the same exact rules, and it applies equally to everyone here, everyone that's at the Law Office of David Shapiro. So that actually ends up being a good thing for clients. And Brooke, why is that?
So it really is a benefit to clients, because since it is all confidential within our firm, we're able to share case details for each client. So say a client calls in and they have a question about their case. If I am able to grab their file and we have, that record, because everything is confidential within our firm, I can easily answer a question. I can, give them an update on their case, and they can feel comfortable speaking to me and giving me details that I can relay back to the attorney. Sometimes, especially, with court hearings coming up and being scheduled here in San Diego, it is really beneficial to use the legal assistant and their confidentiality to your benefit. If the attorney is not available due to a prior conflict, you need to utilize the legal assistant there who has the details on your case and can also relay that information back to the attorney without the potential client or client having fear that that information will leave the firm.
So there you have it. Everything you tell me or Brooke or any of our other legal assistants or members of our team here is going to be kept confidential, no matter who you tell it to here, and no matter when you let us know during the pendency of your case. We take it very, very seriously here, and we know exactly how much responsibility we have being trusted with your very sensitive information that a lot of times the people you love the most and the people closest to you in life don't even know about you. So whether it's me, whether it's Brooke, or any other member of our team, what you say to us stays with us, and we take it very seriously. So if you are facing a criminal case or investigation in San Diego and you would like to give us a call to set up a consultation to discuss your potential options, go ahead and give us a call. Our phone number is 619-295-3555. Thanks, Brooke.
Video number 2, Lawyer Confidentiality Explained.
Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and you're watching All Up in Your Business. On this episode of All Up in Your Business, I'm going to talk about attorney-client privilege and confidentiality and explain what they mean and how they may apply to you if you are working with a lawyer. So let's start with confidentiality. Every state has rules of professional conduct that apply to lawyers who are licensed in that state. These are ethical requirements we must abide by, kind of like do's and don'ts for how to be a lawyer. And if we don't follow these rules, we can get in a lot of trouble, including just losing our licenses. Most states fashion their rules of professional conduct from the ABA, the American Bar Association. And Rule 1.6 of the ABA's Model Rules of Professional Conduct tell us about our duties of confidentiality. It says, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or disclosure is permitted by paragraph B. So what this tells us is that we cannot reveal any information relating to our representation of a client except in a few limited circumstances. And when I say we can't reveal any information, I mean any information. Even the fact that an attorney is representing you in a legal matter is confidential. If I'm representing a famous person, I can't tell any of my friends or family that I'm even working with that person, let alone give away specific details about their case. So what are those exceptions? When can we reveal certain confidential information about a client? First off, if we get informed consent. Informed consent is not just consent. It's not enough if we just ask you for your permission to disclose confidential information. We have to, wherever appropriate, explain the potential risks and any alternative courses of action which may impact your decision to give us that consent. Or we can do it if the disclosure is impliedly authorized. I kind of call this like the common sense exception. Let's say you want to sue somebody because they owe you money, so you hire an attorney to help you. When the attorney files the complaint with the court or, sends a demand letter to the other party, that's technically a disclosure of confidential information because now everybody knows that you have an attorney representing you and they at least know some of the minimal details related to your legal claim. But obviously we have to do this in order to help you. So that's kind of where that implied authorization comes in. So those are just two of the more common situations where lawyers will reveal confidential information. But let's take a look at the third. So it gives the exception for if disclosure is permitted by paragraph B. Let's take a look at paragraph B. It says, a lawyer may reveal information relating to the representation of the client to the extent the lawyer reasonably believes it's necessary. Let's take a moment to appreciate a few things. First of all, it says a lawyer may reveal information. The word may is important here. It doesn't say shall or must. It says may. That means that we can reveal confidential information in certain situations, but we still do not have to. Even where it's permitted, it's not required. It's also important to make note of the part that says to the extent the lawyer reasonably believes necessary. That means even if we do choose to disclose confidential information, we're still bound to disclose only as much as we reasonably believe is necessary. So we can't go on a tirade blabbing about everything just because we're allowed to disclose some confidential information. But let's look at those exceptions. The first is to prevent reasonably certain death or substantial bodily harm. So we can, but again, we don't have to reveal confidential info if we think it's necessary to prevent death or bodily harm, or to prevent the client from committing a crime or a fraud, or to prevent other kinds of injury to another person. But still, it's in limited situations and limited circumstances. To secure legal advice about the lawyer's compliance with these rules. In other words, sometimes there are ethical gray areas, and we're not always sure if we are permitted or required to do something. So we can disclose confidential information to the extent necessary for us to get advice about our own legal requirements, or to establish a claim or defense on behalf of the lawyer, or to respond to allegations concerning the lawyer's representation of the client. In other words, if a client sues us for malpractice, we can disclose information to the extent necessary to defend ourselves against those claims, to comply with law or court order, or to detect and resolve conflicts of interest. This basically just means that, like, if we're working in a law firm, we can disclose confidential information to other lawyers in the firm for purposes of avoiding conflicts of interest. There's kind of more to it, but that's the gist of it. And then finally, we see this last part, which says that a lawyer shall, that's shall, not may, make reasonable efforts to prevent unauthorized disclosure of or access to a client's confidential information. So what all this means is that all information relating to a lawyer's representation of you has to be kept completely secret and confidential at all times, with limited exceptions. But it's not just our current clients that get this benefit of extreme secrecy. A lot of this extends to former clients and even potential clients. If we take a look at Rule 1.18b, we see that a lawyer shall not use or reveal information from a prospective client except as permitted by Rule 1.9. And then if we pop over to Rule 1.9, which applies mostly to former clients, it basically says that we can't use any information in a way that would be contrary to our former client's interests, nor can we reveal any information except as we would otherwise be permitted with respect to a client. In other words, all of the restrictions in Rule 1.6. So, put very simply, us lawyers are prohibited from disclosing any information about a potential client, current client, or former client, with a few exceptions. Outside of those exceptions, everything is top secret. Important side note that I'd like to make here. I beg you guys, please keep this in mind next time you want to ask a lawyer a quick question or get some free legal advice, or next time you feel like, oh, I don't know, complaining because the lawyer doesn't offer free consultations. Solely by speaking with you or responding to a question via email, we now have ethical requirements with respect to you for the rest of eternity. And we're potentially losing out on other clients because now we can't work with anybody else if doing so would place you at a disadvantage, even if you never hired us. All right, so that's confidentiality. Now let's talk about privilege.
But that's for a different video. Thanks for watching and take care.